Hi, everyone. Welcome to the Virginia Adult Use Cannabis Legalization webinar. We're going to get going in just a minute or two, and really looking forward to this discussion. We have some experts that will be able to lay out all sorts of information about this, freshly passed law, not signed yet, but passed, and we do believe it'll be signed by the governor. And so we have a lot to discuss. It's also over 100 pages. So we'll be distilling a lot of that for you. If you uh, require more information, we're certainly available to talk offline. We also have made long and short form summaries of the law, which we're happy to share with folks if they're interested in engaging us for such things. So we'll get going in just a minute or two. I am really excited to have Virginia come on board after legalizing, I think it was in 2021. So it's really been a bit of a long road to get to regulation. But it's a big state. It's an important state. It's an influential state, surrounded by a lot of non-adult use states, not entirely, but mostly. And so I think it's going to be a really robust market. We're going to walk through that. So we have experts that'll be speaking about anything from what does the law say to, what is the application process going to look like in our estimation? What is the market? We'll be hearing from our economist, Andrew, on that, as well as really important corporate considerations. And we're about 2 minutes in, so I'll just sort of turn things over here pretty quickly to the rest of the team. But I guess I did want to say while we're getting settled in our seats here, these laws don't pass by accident, right? And I've been fortunate in the last 20 some years to be involved in a lot of legalization pushes and medicalization law pushes, some successful, some not. But I did want to tip my hat to my friend J.M. Padini, who's with Virginia Normal. It's really been a rock star in pushing this forward for years, um, and as well as other advocates in the state. So certainly, if you're capable of donating to Virginia Normal or other wonderful nonprofits, please do so because these laws are meaningful because they are at the table fighting. And there's other people involved too, but I did want to tip my hat there. So I'm going to start off with kind of a quick gamification here. Our law firm has looked at tens of thousands of pages of regulations on cannabis. And, we had about a dozen of us poring over this 100+ page law. We found it quite similar to a certain state that also has adult use. If you can guess that state that we feel like it's the most similar to or pulled language from and put that in the chat, my partner Charlie will buy you a drink at the next event that we're doing in Richmond. I think we're going to do an event to discuss this topic in person at greater detail, the topic being Virginia's new law and licensing opportunities, I think on the 16th of April. So coming up in Richmond, we'll send more information on that. If you can guess what law this is most similar to, what state law, Charlie will buy you a drink. And we'll have that big reveal later when my partner Meg jumps on. So
And
really
just
quickly,
just just for the record, that's going to be well alcohol, not top shelf.
there you go. Well, we'll see what happens at the bar. So quickly, we're gonna talk through all your questions. Please put them in the Q&A if you can. We'll address them at the end. If not, we're available offline. We have wonderful presenters today. We're going to be talking through corporate issues related to this new law, which again needs to be signed by the governor, but we feel like will be. We're going to talk through the timeline of licensing. We're going to talk through the economics and what you need to know for business plan purposes, and we also will importantly be sort of hitting on how to win one of these licenses, right? And I think that's a real niche that our firm has been involved in. We've competed in every state. I think dozens of states for competitive licenses, qualified lottery licenses, et cetera. And we actually won one of the original licenses back in, I think it's 2017, 2018, which is very merit-based, very heavy lift, and we were fortunate enough to win. So we've got a lot of insight, I think. Of course, a lot will be coming in regulations, but the good news is this is a quick timeline, despite taking years to get this law passed. It is now going to be very pro-business and pro-consumer, and we're going to have cannabis being sold in a pretty quick timeline. So we're going to dive into that. With that said, and I see people lighting up the chat with their thoughts on what law, what other state legalization law has the most similar language to Virginia. Again, share your thoughts. Charlie will buy you a drink. With that, I'm going to turn things over to my colleague Andrew, who's going to talk through the economics of this exciting new law. Andrew.
Thanks so much, Brian. Thank you for everyone for attending the webinar. Really excited about Virginia. We don't get an explosive, billion-dollar plus new market every year, but this one's going to be a good one, and we've been waiting a while for it. So, again, next slide. I'll talk a little bit about the evolution of the laws here in Virginia. So we have to go back almost a decade to 2017/2018 or so, as Virginia passed a very limited medical marijuana law designed for THCA oil and CBD. This was kind of interesting because every state comes up with its own terminology to try to medicalize a law that is regulated at the state level, because medical cannabis, until sort of recently, with some of the rescheduling efforts, has always existed outside of the normal pharmaceutical framework. So instead, they just call them pharmaceutical processors, which again, were not creating pharmaceutical products; they were creating pharmaceutical-like products. But this was a limited opportunity, vertically integrated, a handful of different businesses spread around the state, and with that, it didn't fail to launch, but it was never a robust program in the way that you could look at Maryland, for instance, nearby had a much more robust medical cannabis program. Even Washington, D.C., had a similar number of licenses in its program, and obviously a much smaller geographic footprint. So in 2021, Democrats were able to pass the Virginia Cannabis Control Act, legalizing adult use cannabis. But what they failed to do, because they couldn't really come to agreement on what the regulatory structure looked like, this was okay, we're going to pass this year, and we're going to make cannabis legal because we want to take criminalization off the table, which is really the most important part of legalization. And then the next year we'll come back and, we'll pass a regulatory structure. Now, sadly, they lost the governorship, and I think at least one of the chambers, and they were unable during that time under former Governor Youngkin to pass a regulated adult use cannabis structure until now with a new governor. So in 2024, the Virginia Cannabis Control Authority took over the medical cannabis program. That was a little bit shifts. That was still obviously under the previous governor, and they did put forward some new licenses, or not new licenses, but replaced a license for an operator that was not operating. So now with the new governor, we are able to pass a new law. Now that, as Brian mentioned, hasn't been signed yet, but it's going to be really interesting. So, we're going to see lots of new businesses, and we'll be talking about that throughout this webinar. So next slide, please. Let's talk a little bit about some of the statistics. So, Virginia's got about 6.5 million residents, 21 and over, and almost a million adult use cannabis consumers. That's past month consumers. If you calculate it for past year, we have far more than a million. And then if you consider obviously border consumers as well as tourists, that's well over a million consumers, regular consumers in this that will be purchasing in the state of Virginia. From those residents alone, it's about $1 billion market. And then we got to consider the fact that, got Kentucky, North Carolina, Tennessee, West Virginia. All of those states don't have adult use cannabis laws. There are some states that do border, which do, so Ohio and things like that. But, those represent about another almost 500,000 cannabis consumers within driving distance. So that's about a 2-hour drive, looking at those that are in their counties in those areas. And then on the visitor side, we've got 44.7 million overnight visitors in 2024. Virginia's a big place, both when it comes to some beach areas along the coast, as well as in the DC metro area. So a lot of people come to visit Virginia. People interested in all sorts of American history and things like that. So next slide. Let's talk about the size of the market. So this is a pretty conservative projection. I looked at it. I took estimate of about $150 per month per consumer that are purchasing, with an 8% price decline annually. So this might be a little bit more conservative. But we're looking at about reaching up to maybe a $1.2 billion market by early 2030s. 2027, I don't think we'll actually hit a $311 million market that first year because this analysis was done before the state shifted the application deadline from July to September. So essentially what's going to happen is the businesses are going to open later in 2027. So we'll get a partial year there. Hopefully we get $100 million sales in 2027, but that entirely depends upon how quickly the licensing occurs and how quickly that build out occurs. But from then we'll ramp up relatively quickly up into the high 800s into the billion-dollar markets, and then over time decline as prices decline once those markets stabilize. Obviously, if we start to see significant political movement in a place like North Carolina or others, that will draw from those consumer base. But I think for the most part, Virginia's market will be a healthy $1 billion or so market. All right, next slide. Let's just talk a little bit about what economic analysis we might need for the Virginia application. So there's a lot, and Meg and Charlie will talk about this extensively, but there's a lot that is going to be subject to regs. So we don't really exactly know the details of what's going to be required in that application. We know a lot about what the application process might look like, but things like your business planning, projections for revenue and cost, that's subject to future regulations. I think it's likely we're going to need that, even in a place like Maryland, where they did a qualified lottery, with a really streamlined, small, business plan requirements and financial requirements. There still was revenue projections and things like that. So, the firm is here to help and help provide some of those data and statistics. The other important thing is, many of these new adult use cannabis states passed in Democratic legislatures have provisions, and Meg will talk about this extensively, for impact licensees or social equity licensees, all have different names. And sometimes those are dependent on you've got arrest or other things like that in combination with your physical geographic location. So in Virginia, it's called a historically economically disadvantaged community. And with that, there's some economics and some calculations that we need to make and that the state will be making about marijuana possession arrests at a really small census tract jurisdictional area, as well as being an underutilized business zone. So if you have any questions, obviously the state will be coming out eventually with that data. But if you're doing some searching and you need some assistance in trying to identify does this area likely qualify, that's something that we've done in Maryland and other states in the past, and I'm happy to provide here. So I'm going to pass it on, and thank you, Gia.
Thanks,
Meg,
Andrew.
yeah.
My name is Meg Nash. I'm very fortunate to have worked with clients in Virginia before, as well as across the country. I want to kind of kick things off with the big reveal of what kind of the Vicente team decided was the kind of most similar law. We kind of put our heads together and landed on Minnesota as the most kind of comparable here. But at the risk of setting up Charlie for a massive bar tab, I'm going to go on a limb and say there's no wrong answers. I saw a lot of people put Maryland and Massachusetts in the chat, Michigan, and there's certainly some carryover from a number of different jurisdictions, New York. And that's kind of what we tend to see in these states that are on the ladder curve of legalization. They have the benefit of taking what has worked in other states and incorporating them into their legislation, and kind of excluding things that have been phased out through further legislation and processes in states that were on the earlier tide of legalization. So hats off to you, Charlie. It's going to be a good night. Before we get into the nitty-gritty here, I did kind of want to provide a broad lens overview of what we know now that the legislation has passed. Essentially, this creates the backbone for the regulated cannabis market in Virginia, and that is going to fall under the Cannabis Control Authority's kind of umbrella of regulations and administration. This, of course, is extremely exciting. I think we're as excited as you are about this development, particularly given sort of the unique chronology in Virginia where they had this legalization but no regulation. This has really been a long time coming. You may recall from sort of following the initial introduction of legislation that the prior versions had sort of this back and forth about dates. Happy to say we have that nailed down now. The CCA must begin accepting applications on September 1st for certain license types, and they must also promulgate regulations by September 1st, 2026. In the prior versions, it was kind of at July with sales to maybe begin in November or January. The January 1, 2027 date won out, so regulated sales will begin next year. And the license caps have remained consistent from the prior versions of the bill, capped at 350 retail marijuana stores and 5 Tier 5 cultivation facilities until January 2028. So, kind of off the bat, wanted to kind of call out what we know now, what got resolved in the final legislation to kind of orient ourselves going forward. Another thing that's remained consistent is the total different license types. This has stayed consistent through, kind of the evolution of the law. The first type is the marijuana cultivation facility. Obviously, a lot of the operations that are permitted under, the type of license are in the name itself. But there are some unique considerations that we wanted to flag here by kind of detailing the scope of operations. So for cultivation, particularly wanted to highlight that this allows for transportation of marijuana between licensees in addition to cultivation, labeling, packaging, as well as the different tiers. So that limit on the Tier 5 licenses, Tier 5 is 35,000 square feet. So that's obviously quite a large undertaking, but really a range of what the other tiers are kind of scaled and shown on the slide below. For Tiers 1 and Tiers 2, there can be indoor or outdoor cultivation, but once you get to 3 through 5, it must be indoor cultivation. So wanted to flag that because that is obviously going to be a consideration when you're looking for property locations, and that, kind of fundamental backbone of what your operations are going to be. So good to know at the outset. Similarly, there's a processing facility license available, allows for processing, labeling, packaging, but also the transportation between licensees. Retail marijuana store, kind of what you would expect. Although again, wanted to flag that it does allow for transport between retailers, and it also allows for direct to consumer deliveries through their own employees or through a delivery operator. And the statute itself sets a limit on 2,500 square feet per location. I anticipate that, we'll maybe get a little further clarification on that, whether that's sort of specific licensed premises. For example, does office space related count towards that 2,500? So yeah, more to come, but still kind of a clear picture of what these licenses or operations are going to include. The micro business is a vertically integrated license. So that allows for all 3 operations: cultivation, processing, and retail. And they will be allowed to interact with all other license types up and down the supply chain. So one of the reasons I wanted to kind of call out the scope of transportation on the cultivation and processing licenses is because Virginia also includes a specific transporter license, and that is limited to B2B transportation, but does allow for product storage. Similarly, the delivery operations allows for direct-to-consumer delivery, but also allows for product storage. So we're going to get into kind of property specifics a little bit more. But for these license types in particular, I anticipate that location will be important because, this is going to be sort of a linchpin between where other licensees are located. For example, if there's a number of cultivation processors, retailers all in the same spot, they'll likely just be transporting with each other and may not utilize a marijuana transporter. Versus if there's a larger geographic distribution, if you can kind of make yourself the transporter in the hub, it's going to be allowed to kind of distribute out more broadly. that's going to be a consideration for a transporter licensee. Similarly, for delivery operations, if there are not a lot of retailers in a certain region and you can kind of purchase and store product and then deliver direct to consumer, that's going to give more of an advantage. If you're not competing with retailers who are also allowed to deliver to consumers. Marijuana testing facility, just what you'd think it is. And then the dual use permit for existing medical operators. These are the licensees that are likely going to be sort of benefiting from that January 1, 2027 regulated sales deadline, because they're obviously up and running already. But remains to be seen with respect to the licensing timeline. We'll sort of provide our predictions later in the presentation. Some additional key takeaways now that we have the final law. As Andrew mentioned, sort of impact licensees, this is definitely going to be prioritized. Vertical integration is permitted, via the micro business, and also the existing pharmaceutical processors are vertically integrated. I'm going to let Charlie kind of speak to this undue influence factor a little bit. With respect to fees, we know that there'll be a $10 million conversion fee for dual use marijuana facility licensees. Again, this was one of the sort of numbers that had competing values in different versions of the bill, but we're resting on that. Although there will be permission for installment payments for those of you who guessed Maryland. I think that's a carryover there. Similarly, there's a $500,000 conversion fee for hemp processors or growers with installment payment plans permitted there as well. On the tax side, landed at 6% retail tax for marijuana. That's down from 8% in the prior iterations of the bill. And it does expressly state that localities can levy a local tax of no less than 1%, but no greater than 3.5%. That I think is somewhat borrowed from Massachusetts in limiting kind of the localities with respect to the tax limitations and providing direct kind of guidance on that factor at the state level, trickling down to the municipal level. So looking at the impact licensees, again, this is comparable to a lot of other states that have prioritized, I think, importantly, kind of promoting the participation in the cannabis industry from groups that have historically been disadvantaged by the criminalization of cannabis or marijuana. So what that's going to look like in terms of the benefits of being an impact licensee, it will include preferences in the licensing process, a waiver of a percentage of application or license fees, increased access to a low-interest business loan program, and waiver of any requirements to show proof of funds or current possession and control of the proposed licensed premises at the time of the application. Although I'll sort of add an asterisk to that last point, where the legislation does not include sort of express requirements on capitalization or property for any licensees for the time being. So that may be sort of borne out further in the regulations. Another key factor here is there's sort of express reference to the fact that the CCA will seek to ensure a proportional distribution of the available licenses among impact licensees. So we're not sure if this is going to land at, 50% of the awarded licensees go to impact licensees or what this is going to look like. But again, very much speaks to the policy priority of ensuring that there's kind of appropriate distribution of licenses in Virginia. So now that we know sort of the benefits of being an impact licensee, we want to drill down further on how do you qualify as an impact licensee. So Andrew had sort of touched upon this earlier. The eligibility here is determined by a two-pronged evaluation where individuals must show that they resided either between the years of 99 and 2025 in a disproportionately impacted area, or for at least 3 of the past 5 years in a historically economically disadvantaged community. So typically what we'll see is that the state will release information about, a disproportionately impacted area or a DIA, as well as information on historically economically disadvantaged communities. Typically, that would be, related to Virginia alone. And it can take a while for the release of that information. There's nothing expressed in the legislation that says that it has to be, a DIA in Virginia. And in fact, there's been a lot of, sort of litigation challenges in states where residency has been a requirement. So I expect that we will learn more on that. But just to sort of sing my colleague's praises, Andrew here for a moment, there's a lot of data, a lot of analytics that go into sort of making these determinations, as well as a lot of documentation that can be required to sort of prove up that where the census you live in falls into one of these categories. He's dug through FOIA requests and reached out to police departments in the past. So to the extent that we can be helpful there, you wouldn't be in better hands than with Andrew working on that. He's very well versed in this process. In addition to those kind of one or the other, you have to hit A or B, not both. If you hit one of those, then you also need to fall into one of an additional 6 criteria. And that's basically a prior conviction, family member with a prior conviction, prior attendance at a public elementary or secondary school located in a historically economically disadvantaged community. Those are always interesting records requests to dive into, because not only do you have to have sort of the underlying economic data, you also frequently have to go through any existing Department of Educations in case your parent didn't save your report card from your elementary school. So that can kind of be an involved process. Similarly, if you've received a federal Pell Grant or attended for at least 2 years a college in which at least 30% of the students are eligible for a federal Pell Grant. Those of you who guessed Maryland, that's pretty much a direct transfer from the social equity qualifications in Maryland as well. And I think that that was the first state where we saw any references to Pell Grants. So we have more experience there, having engaged in a lot of licensing in Maryland. If you're a veteran of the armed forces or have qualified for financial assistance or relief from the U.S. Department of Agriculture as a distressed farmer in the last 5 years. So there's a number of different buckets that you can fall into, and hopefully that will cast sort of a broad net. But the documentation required to kind of demonstrate that you qualify can be the first hurdle. So this is one of those things that to the extent you can get ahead of, and as soon as we know more from the state, it's going to be important to prioritize if you want to kind of pursue that impact licensee opportunity. So to that end, we'll speak to a little bit of the application readiness. As I just mentioned, sort of the impact licensee is its own animal in terms of making sure you're ready with respect to sort of unique documentation that's required, some of which is harder, easier to come by. In addition to that, it's important to think about sort of your corporate structure, financing, real estate, intellectual property, particularly if you're an existing cannabis brand in another state, as well as the team of professionals that you're going to be working with. This obviously includes attorneys as well as CPAs and subject matter experts. For example, maybe you have some processing experience, but not directly in the cannabis industry, and you want to pursue a processing facility license. It's going to be important to start reaching out to sort of industry experts, whether they're, being invited onto your cap table or as a consultant, really focusing on building that team to make sure that you're set up for success from the outset. Next thing is always going to be important in any entrepreneurial pursuit is capitalization. As I mentioned earlier, there isn't an express capitalization requirement, but there is specific language saying that a license may be refused if the applicant has not demonstrated financial responsibility sufficient to meet the requirements of the business proposed to be licensed. So this is based on the language saying the business proposed to be licensed. This will be variable on what you're going after. So for example, the startup capital to establish and operate a retail establishment is typically much lower than the startup capital required for a cultivation or processing facility. Again, sort of looking to Maryland as a reference, there was during the supplemental application phase a requirement, different tiers of the precise amount of money that what you were required based on license type. Virginia did not adopt that specifically, or at least has not adopted that yet. But that's sort of a point of reference for the range of funds that might be connected to the type of license that you're pursuing, to kind of keep in mind depending on your specific area of interest. We may see more in the regulations, which again will be released in September, but we certainly have some data points from other markets to help sort of make informed decisions about the amount required. And not only that, Andrew on our team in economics and just our general team's experience in licensing can certainly provide data with respect to, what you can anticipate as you launch your business. Finally, we'd be remiss if we didn't talk about property. The legislation does not specifically require property control to apply. But what we've typically seen is that the largest risk of losing preliminary licensure or preliminary approval or to obtaining a final license is failure to secure property. So as sort of a general recommendation, it's always good to look often and look early. Once you sort of get that preliminary approval, you're going to have to ensure that the licensed premises conform to the requirements of the governing body of the county, city, or town in which it's located. And this is not only zoning, but also, sanitation, health, construction, equipment, any other regulations, anything else that the regulations may say, and that it's not going to be in violation of peace and good order. Frequently, when new adult use markets are starting up, there can be somewhat of a default NIMBY approach. So sort of making sure that, if you're identifying a community, a municipality, if you're proactively reaching out to municipal officials, proactively reaching out to the community, educating the community, that typically demonstrates, not only goodwill and positive neighbor mentality. It can help you get ahead of unanticipated things that may come up when you're on a bit of a tighter timeline post preliminary approval. So that's why we kind of tend to recommend that this stay on, any applicant's radar, even when it's not required. For retail stores in particular and micro businesses, there are specific setbacks. You have to be 1,000 feet away from hospitals, public, private, or parochial schools, institutions of higher education, and child daycare programs. Kind of depending on where you're looking, there can be a lot of these different facilities. So again, always good to start looking early. The law does expressly state that governments are not allowed to prohibit marijuana businesses in their jurisdictions, but they can institute time, manner, and place restrictions. Sometimes, again, if you see sort of a carryover stigma or somewhat of a NIMBY approach to this, municipalities won't prohibit it, but there can be sort of high bars to get those approvals. So again, the more sort of proactive you can be in thinking about where you want to locate your business, and who you might want to reach out to, in the community to kind of have a as warm an entry as possible, that always seems to yield dividends in the end. We wanted to set forth some kind of goalposts here. Obviously, there's an element of crystal balling here. We know that they'll begin accepting applications in September. with sales to begin on January 1. With the sort of acceptance date at September 1, I think it's reasonable to anticipate that the application materials themselves will be released in advance of September. If they're going to sort of open up the submission portal or whatever the submission methodology is in September. So sort of calculating back from that, I think it'll be important to think about having your entity formed by April 1st, or certainly within the month of April. This is going to be important, particularly if you have a specific name or a specific brand. You want to make sure that that name is available. That can include a Secretary of State search, and kind of making sure that you can kind of plant your flag, if you will, on what your name is going to be in the state. Kind of by May 1, you're going to want to be thinking about making sure you have a strong team in place, not only with respect to professional services, but starting to identify any consultants, additional owners, investors, that you're going to want to include in your application. And then really focusing on capitalization through June of 2026, with the idea kind of holding over from the prior legislation versions that we might have the application by July, and then submission by September. Again, I want to kind of asterisk this all with, these are informed guesses, and we'll have to wait to see more. But what we've been hearing from clients is that they're very eager to kind of know timeline here. So we thought it was important to share our initial thoughts, so that people can plan appropriately. Finally, the application process, before I kind of let Charlie chime in here on more of the corporate pieces. We do know now from the legislation that this will be a qualified lottery. And that's in the event that the number of applicants exceeds the number of licenses available. In extremely rare circumstances, the number of applicants has not exceeded the number of licenses available. So I think it's fair to assume that this will ultimately end up in a qualified lottery. There will be separate lotteries for general licensees and impact licensees, and any impact licensees that are not selected will be added to the general lottery. So, this is likely to result in a smaller lottery pool for impact licensees and then a larger lottery pool for general licensees, but that remains to be seen. With respect to the application evaluation itself, we do not have any insight on that yet, other than what we've seen through the past pharmaceutical processor applications. In the most recent round, there was scoring based on different sections of the application, and applicants were required to obtain a minimum number of points in order to get entered into the lottery. I think it's reasonable to assume we'll see that again based on prior licensing rounds, but we'll have to wait and see. Hurry up and wait here. With respect to the post-lottery requirements that we can draw out from the legislation, applicants who receive preliminary approval will have 18 months to provide the CCA with property information, and that's going to include proof of all compliance with local zoning. There will be a one-time 8-month extension permitted if applicants can demonstrate good faith efforts. So, again, I think that this just kind of speaks to the importance of looking at property from the outset, looking at communities from the outset, because what we've seen in other states is that 18 months goes very quickly. Thank you all for your time. Certainly let us know if you have more questions. I'll let Charlie kind of chime in here on some of the more corporate and financial considerations going forward.
All right. Welcome, everyone. Thanks for sticking out the 40 boring minutes of application talk. You've hit the exciting part of the presentation. Can we go next slide, please? Next slide. Oh, sorry. We initial, sorry, go back. I apologize. Go back, please. Yeah, so these are kind of just general. This is application stuff. It's just application stuff. This is just in terms of, the corporate stuff when you're applying. You just want to make sure your books are in good order. This is a qualified lottery application. So I think a lot of people are going to kind of do this where they're, just throwing in an application and then, investing resources later. So you don't necessarily have to get everything, super buttoned up, but you don't want to be in a position where you win a license and then, oh yeah, by the way, we actually don't have like a signed operating agreement. We don't actually know who owns the company. It's a recipe for a nice dispute, right? So you want to get the basics locked in and keep that well organized. Next page. Yeah, this part I think will get pushed. So the rules are supposed to we talk about this later, but the rules are supposed to come out by September 1st. 2026, we'll probably see draft rules before we get the final rules. But this is something where it's very common in a state that the ability to change ownership will shift through the licensing process. So yeah, I know I'm a little bit blurred here. Hold on a second, let's see if I can fix this. So it's very common where in a preliminary licensing phase, before you get the final license, you may not be able to make as many changes to the ownership structure as you can in the final licensure phase. So just be aware of that. This is something we're gonna have to wait for rules. Social equity has stricter requirements that we'll talk about in a second. All right, M&A, again, this is just sort of general, not necessarily specific to Virginia. We'll dive into the Virginia rules, but I talk about the basic stuff because we've got the statute here. We don't have the rules. So this will change a little bit. But, is written pre-approval required prior to closing a transaction? That's not the case in all states. It is going to be the case in Virginia. We just don't have the process yet. Our local license approvals, right? So in some states, like a Massachusetts, California, local licensure approval can be just as difficult as state licensure approval. We're not going to have to deal with that here. There is some zoning and local stuff in Virginia, but there's not a local license. Are workarounds regulated? Yes. They seem to be quite tightly regulated in Virginia. We'll get to some details later. We're going to have to see what the rules look like, how difficult it is to move a license. We're going to see the rules on that. And then what are others in the market doing? This is the big one, and you got to be careful to work with the lawyer who's actually in the market, because you've got the rules as written, and then you've got what actually happens in practice. I pick on New York because New York is like the most egregious example of this. Is if you just read the rules in New York, you would say, well, you can't do an M&A deal in New York. And then you talk to a broker in New York who says, I've signed 50 of these. There's zero regulatory risk. By the way, take everything a broker says with a huge grain of salt. But the people do deals if there's no enforcement. So this is obviously, this is also a plea to regulators, which is, it's not you say in the rules, it's what you enforce, is what you get in terms of what happens in the marketplace. Next slide. Equity consideration. So if you're raising equity for a company, and I think in most cases, what's going to happen, I think in Virginia, is you've got this qualified license process, qualified lottery process. So people are going to lob in lottery tickets. If and when they win a lottery ticket, then they're going to raise money, because nobody's going to invest in your company, right? When you're going to say, hey, invest in my company, we're going to apply for a lottery, we're going to apply in this lottery. And, they're going to say, well, listen, come to me when you win a license, and then I'll consider investing. So you got to think about what's the materiality level for approval, whether you can give these investors veto rights and control, whether if they get added to the board that requires approval, whether they get background check for that. Are the investors comfortable with the background check? What will that background check look like? And are any of these people going to be publicly listed? And then roll and close. Most states with the materiality threshold will allow you to do a roll and close, meaning that you don't have to bring all the money in at once. If a state says, hey, every single shareholder has to get blessed by the regulator, regardless of materiality threshold, then you can't do a roll and close. And frankly, you're not going to be able to raise money. So I would give up immediately. Luckily, in Virginia, there's a 10% materiality threshold. Thankfully, they've created a system that will allow you to raise capital, which is just another reason why I think Virginia is going to be a great market. Next slide. Debt. These are the things you got to think about when you're raising debt for a cannabis company, right? We're going to speed through this because running out of time here. But the bottom line is, I think any debt in Virginia is going to have to require approval from the regulators because it says any financing arrangement requires written pre-approval from the board. That's a little bit unusual. Most states don't require pre-approval for debt. Maybe I'm wrong. We're going to have to see in the rules. We'll talk about that when we get to the Virginia section. Next slide. Yeah, equity considerations. This is just my general advice to people raising money in cannabis, which is figure out the regulatory regime so you've got a good answer for the investors when they come. Think about structure and don't try and reinvent the wheel. I see this all the time. People come up with these crazy regulatory, capital raise structures. I mean, in some ways, this gets a little worse with AI, where you can kind of like iterate with AI and create a crazy structure. Instead, ask AI, what's a normal way to raise capital that my investors are going to be familiar with? So this is like safes, convertible notes, price rounds. Remember, securities laws apply even though you're in cannabis. Securities law is very focused on disclosure. There are filings you need to make at both the federal and state level when you're raising capital, though, of course, people don't always do that. Be wary of investors without previous cannabis industry experience, mostly because they're the ones that are going to create an issue with you from a background check perspective. So the worst thing to be in terms of a position as a cannabis company is, you get the Virginia cannabis regulator saying, hey, we need to background check this investor. The investor says, I'm not giving you those documents. It puts you into an impossible position because the regulators will have no sympathy for you. They will have no empathy for the difficult situation you're in, and they will probably pull your license or refuse to renew it if you don't give them the appropriate documents. So you need to make sure that your investors are going to be comfortable with whatever background check process they're going to have to go through. And just be aware that these things can lag, right? You can be sitting still for a year, right? And then you get to renewal, and at renewal, they ask for stuff. And finally, if it's too good to be true, it's a scam. That's always the case in cannabis. So, if someone's like, I'm going to get you debt at 6%, that's a scam. I bet my life on it. So just be really careful. Next slide. Okay, so let's talk about Virginia specifically. So ownership is defined as 10% or greater equity, voting, or economic interest, right? So one thing I would note right off the bat is there's no discussion of convertible interests. So I think arguably an option to buy a company is not ownership because that's not voting or an economic interest. States that try and pick up options usually talk about contingent interest or future interest, like you see that language in New York. You don't see that language here. So if someone has an option in your company, they probably don't have an ownership interest in the company. Maybe that changes with the rules. Maybe we get guidance, but for now, it's not really clear. Officers, directors, managers are included, and that's important because they're going to have to go through a background check. I'm just going to kind of speed through this so we have 5 minutes at the end. Mandatory tracing through all intermediary entities. But remember, you've got this 10% materiality threshold, right? So it's like if someone's a 1% owner in your company up through 10 or 10, bunch of different entities, they don't have an ownership interest. But they do go to the ultimate beneficial owner, very common. And then there's no exception for public companies. But again, you've got a 10% materiality threshold, which is usually what states will include for public companies, as an exception. Next slide. All right. So other big corporate issue, of course, is vertical integration license caps. So there, vertical integration is permitted here, subject to both caps and this undue influence, which is a separate issue. 5 licenses per person, excluding transporters. I should also mention with vertical integration, testing licenses usually, so like micro businesses and testing, as I put here at the bottom, that's outside of the vertical integration permission. So like you can't have a testing license and another license for obvious conflict of interest reasons. But so, I mean, how this matters in terms of application is presumably you can apply for up to the number of capped licenses, right? In the round. So you could apply for 5 retail, right? If you're comfortable with the fees, that's going to maximize your chances in the lottery because they could theoretically award 5 to you. Now, I doubt that they would award 5 to the same person because of concentration issues. But I mean, based on the corporate stuff here, I don't think it's impermissible. Next slide. Yeah, so like we were talking about again, a big part of cannabis transactions is when you need approval, right? So one thing that's nuanced here, I haven't seen this in other states, is if you do more than a 25% cumulative change in ownership within 24 months, that requires approval. So again, there's a 10% materiality threshold. So theoretically, right, I could sell 9% to Brian, 9% to Andrew, 9% to Meg, right? And there hasn't been a change in ownership interest, right? But what they're going to say is, well, that's over 25%, so you need to get approval for that because if it's sort of like it's like a loophole or an end run around it. Next slide. Yeah, so this is the undue influence. So it's interesting if you go back and look at earlier versions of the bill, there was an earlier version of Virginia that followed the alcohol 3-tier model. So I'm going to just show off. If you're a scholar of liquor, you got to read this toward liquor control, commissioned by none other than John D. Rockefeller Jr. And this is sort of like the guiding light of American alcohol law, which creates this doesn't actually require the 3 tiers, which is the separation of production, distribution, and retail, but it does sort of create this concept of control, right? Which is they really want the state to strictly control liquor because they're afraid of liquor. And one of the concepts that come out, idea of undue influence, which is that you don't want the alcohol producers to be controlling the retailers because there used to be a big issue in America with saloons being controlled by the producers of alcohol. And it created a lot of problems in terms of crime and alcoholism. So they don't want the producers to control the bars basically in alcohol. So they've ported that over into into cannabis, and they don't want the stores to be controlled by the big producers. Now it's a little bit strange here because you are allowed to be vertically integrated. So if you own the store, presumably this doesn't apply. But if you don't own the store, you can't really control these stores through, shelf price setting, shelf space, financial dependency, shared personnel. So there's all these kind of these rules, and this is the alcohol concept. I should also note that the ABC, the alcohol regulators in Virginia, has shared enforcement authority under this bill, and there's a commission that's meant to be published in terms of potentially putting this under the ABC purview. Some of the different bills had the alcohol regulators controlling this, and some of them had the cannabis regulators, ultimately with cannabis. But there is this could ultimately go back to alcohol. So it's just kind of an interesting kind of crossover between cannabis and alcohol. Next slide. Yeah, and then this is interesting, right? It's like they want to use HHI concentration benchmarks in terms of market share and market concentration in terms of like approving or denying deals. Now, I mean, there's 350 retail stores, and if you could only own 5 at max, I don't know how your concentration is going to get super high, but it does mention regional. So maybe if those 5 stores, or maybe you own 4 stores in a small area and you want to buy a 5th in that area, that could be an issue. I don't know. This is another thing that I think is a little new. I haven't seen cannabis laws mention HHI. Next. Yeah, impact license. Impact license. We get a whole seminar on this, but yeah, raising money for social equity licensees is very, very difficult because they want the social equity person to have what they call direct control. And I use scare quotes because I don't know what direct control means. It's not defined in the bill. Maybe it'll get fleshed out in regulations. We've seen more details in other states, But essentially, what it usually means is if the investor wants to have their investment protected, the regulator is going to say you can't do that. That constitutes a violation of direct control. And then the investor pulls the deal and the social equity license never opens. So, you have to, these are very delicate transactions. You have to be careful how you structure it. And they can revoke the license and say, hey, you got to pay back all the fees. So this is something that's, and of course, you've got the 5-year restriction on transfer. Next slide, I'm going fast here. Give us a second for a question at the end. Yeah, big one is the rules. One thing I'm really paying attention for, obviously, is the approval process to approve or deny ownership, financing, management, and brand licensing agreements. I'm particularly interested in financing, management, brand licensing agreements because, like in cannabis, if they won't let you do an M&A deal in other states, usually you do the deal through some version of options, MSA, IP licensing, right? Or you do it as a debt deal, right? But if all those are subject to approval or denial, then it's not really a loophole. So I'm curious what they say here. Also curious if debt requires pre-approval. That's a little bit sort of an open question. More detail on direct control. It's great, by the way, to give a credit to Virginia that they're going to have a process for change of control by September 1st. I mean, New York has been open for how long, and they still do not have a process for change of control. So I think it was a great idea to put in the bill that you have to have this change of control stuff by a certain deadline, because otherwise, capitalism doesn't work without M&A. You need a way to trade businesses, or else like the system kind of becomes highly inefficient. So I rushed through a bunch of stuff here. We don't really have time for questions, but if you stuck around this long, thank you. I would like to pitch April 16th, Richmond, Virginia. We're going to do a happy hour and another sort of little high-level overview of the Virginia system. We'll be sending out information on this, but it'd be great to meet people in person. I'm incredibly excited about the Virginia market. I'm based here in Bethesda, Maryland, so right across the river from Virginia. I think this is going to be a fantastic market. It's a great law. It's no local control, no local bans, limited licenses, reasonable rules. This is going to be a fantastic market. It's certainly going to be the best new market of 2026. I mean, it's really only competing against Nebraska. But super excited. These are our contact information. This is going to be put up on YouTube, so you'll all get a copy of this. You get the slides too. Please reach out. Happy to work with anyone here. If you're an out-of-state lawyer, you need a local person to help you, can help you there. Obviously, operators, investors, licensees, impact licensees, everyone, we'd love to help you with this. We're super excited about Virginia, and we're going to be following this very closely. Make sure if you haven't signed up for our email listserv, because you've got the applications coming out, then you're going to have the rules. So there's going to be more stuff we learn along the way. Anyone else want to say something? I was just sprinting here.
Charlie, I wanted to say thank you. Well, we did have a bunch of questions. I'm going to attempt to hit a few of those in a real lightning round here. Let's go to, and Charlie, I agree with you, having done this working in a couple dozen states, this is going to be a heck of a market. It's limited license. These licenses are going to have real value. Some other positive things, Andrew, talk to me about the tax rate here for consumers. What does that look like compared to other states?
It's among the lowest in the country. So I was just checking it out. 6% cannabis sales tax rate. Here in Colorado, we're dealing with a 15% sales and 15% excise. And the state has a relatively low sales tax rate normally at a 4.3%. So, Maryland just increased its taxes from 9% to 12%, which by comparison amongst other states is still low, but yet is twice as high as Virginia. So, Virginia cannabis businesses will have a competitive advantage when it comes to that neighbors. And I didn't even factor in border consumers from Maryland coming down to Virginia, but with that differential tax rate, they might.
Oh, yeah, that's a great point, right? And we've certainly seen that where folks are crossing from Ohio into Michigan to get, less expensive weed, less expensive taxes, although the taxes have shifted up there. I'm going to give it to Meg to close in 30 seconds. Meg, I've had a couple questions about, consumers. What can they buy? What can manufacturers make? What are dispensaries going to be selling?
Well, Virginia's come a long way since the early days of THC oil only. There's going to be sales of flower, concentrates, inhalable products, topicals, edibles, as well as paraphernalia. We don't know from the legislation itself specific dosing amounts, but since there is a medical market, reviewing some of those menus, although the medical thresholds are often higher, that'll give you kind of a sense of what's available in the market now and what we expect to see consistent on the adult use side.
Thank you, Meg. Thank you to the other panelists. We're excited about Virginia. We've done a lot of good work there, and we'd love to work with you. So shoot us a line. Thanks so much. Have a great day, everyone.
And see you in Richmond.
See you in Richmond.
Thanks all.